Hello, my name is Jo Haig. I'm the chairman of FDS. Welcome to our on-demand webinar on business prenups, why shareholder agreements protect value when relationships change. Quickly about us, I started my company 36 years ago. In 2020, we transferred to an employee-owned business. We are sector agnostic, but probably our main speciality is owner managers. As chairman, as I said, I started the business way back in 1989, and we are now an employee-owned business. I'm non-executive director and chair of a number of companies, along with my colleague Poonan, who is our CEO. Both of us are the people that are involved in most of the transactions. Poonan is 25 years qualified in accountancy and corporate finance, also award-winning and chair of the Institute of Directors in West Yorkshire. Okay, so shareholder agreements. What I want to tell you about is these are a little bit like a prenup, except in the UK that shareholders agreements are binding. Prenups are not, but they are increasingly being taken into account by the courts. When I got married the first time, I didn't expect 14 years later to be divorcing and my husband and I to be arguing about a lamp, but it happened. And unfortunately, when you are at that stage in a relationship, be it business or personal, all objectivity goes out of the window. And that's why it's important, because when you start a business with a colleague or other colleagues join you later, you don't expect to part, but unfortunately it does happen. And what a shareholder agreement does, in the same way as a prenup does, is it protects the value. And it means that while emotions may be there, you've got a contract that is binding, that will take away as much as the hurt as possible. If I'd had a prenup that said these lamps will be yours, then all the arguments about that and the other many insignificant items in retrospect would not have been an issue. So, of course, valuations are very important in a prenup and in a shareholders agreement. And as mentioned, different motives create different numbers. If everybody's happy and don't expect to get divorced or don't just split up from their shareholder, then you can talk about this calmly and agree, well, if we fall out or if one of us wants to leave for whatever reason, we can agree on how the business would be valued. If you haven't got this in writing, the only people that win are lawyers, and you have to get involved in some horrific fights arguing about who's having the lamp or who's having the company. It's very important to be specific in a shareholders agreement how an independent valuation is arrived at. So one of the things that I recommend is either putting a formula in for that valuation or saying that it has to be done by a third independent party. That is definitely not your auditors, by the way. They will always favour the persons remaining in the business. But most importantly, that valuation is binding. I've seen so many agreements where it says the valuation will be done by an independent party, but if it doesn't say it's binding, all that does is give you another piece of paper and another cost and another situation where you both start to argue. So one of the things that can happen is you might be at some sort of deadlock. Perhaps one of you wants to turn left, one of you wants to turn right, one of you wants to do an acquisition, one of you doesn't. And particularly in 50-50 relationships, and that of course could be spread across a number of shareholders, it doesn't have to be 150 and 150, then you get a deadlock and therefore nothing happens. By putting a provision in to deal with that, and I'll explain some of these provisions later, what you have is the ability to continue the business on a pre-agreed strategy. Valuations are always a struggle to come to where there is no agreement in place, with one partner feeling more aggrieved than the other, or even in a more sensitive situation, perhaps when one of the shareholders had died. How do you value the bereaved estate? So having that valuation mechanism set up in the first place can allay all those issues. It also clarifies what everybody is allowed to do and what they're not allowed to do and when they have to do it. And to a large extent, it will remove the lawyers. Well, perhaps not all of them, but will remove a lot of them. And while I am a lawyer myself, getting lawyers involved in legal issues that could have been sorted out in a contract is just a waste of time, and it's certainly a waste of money. Okay, now there are lots and lots of clauses, and if you wish to work with us, we have a very extensive checklist to go through with you of what you want in an agreement and what you don't want. Some things are set in law, other things you can actually write in the agreement. So for instance, let's say you had a shareholding with 75% shares held by one person and 25% held by another. And somebody comes along and wants to buy the whole business. And the 75% shareholder says, yes, definitely. And the 25% goes, no. In law, you cannot drag that person on automatically to sell their shares, which may, of course, mean that the whole deal is aborted. If you have a drag and tag clause, you can drag them along, and the percentages is something we would discuss with you. Also, you can't leave them behind, which is what tag means. Where you have shareholders with less than 10% of the shares, that is covered in the Companies Act that you can automatically drag them along. But anything above that, I'm afraid you have to write this into an agreement. There are lots of legal documents when you set up a company, and one of the ones that everybody has to have is Articles of Association. Articles of Association are the rule book for the directors, and they're available at Company House, and anybody can look at anybody other's articles. A shareholders agreement, however, is a completely private document, and it only binds the shareholders that sign it. And less importantly, in such a document, you have something called a deed of adherement. That automatically means that any new shareholders that enter the business, they are bound by whatever is in that agreement. Preemption and buyback provisions. Of course, there becomes a time where you may wish happily to sell your shares, and perhaps somebody has approached you and given you an offer to die for. However, what you need to do is to put in the shareholders agreement the process by which how that process should take place. So that starts off with, you can't just sell your shares to a random outside the business. You have to offer them back in an order, usually starting with the company and then the other shareholders. And then there is a provision for timing and process on that. If you don't have such an agreement with this in place, anybody in your business can take their shares and sell them to anybody, maybe the competition, and that doesn't make good commercial sense. Valuation methods can change as well, and this would also be in the agreement, depending on whether it is a positive exit, somebody's retiring, for instance, or a negative one where there's some sort of dispute. Linked to that are what we call good and bad levers. So a good lever would be somebody who is retiring, who's no wish to remain involved in the business and they want to realise their shares. A bad lever might be a fraudulent one. And so it's important to classify those because the reference to that is how you then affect the valuation. Equally, minority discounts, while your business, let's just take an example, might be worth £1 million, 10% without a minority discount clause would mean that their shareholding is worth 100% on an exit. However, it's more usual in a shareholders agreement to apply a discount to that. So you may apply, say, an 80% discount to somebody with 10% or less of the shares, because with such a small shareholder, you can do very little. The next thing is a cross option, and a cross option is important if a beneficiary of the shares dies, because the will of that person, if they have a will, or if they don't, even worse, and they die intestate, such shares would pass to whoever they wish, which could be their children or the cat's home or their partner. And therefore, as the rest of the shareholders, they may feel rather aggrieved if they now have a shareholder who knows nothing about the business, perhaps the children, perhaps the charity. A cross option forces that beneficiary to sell the shares back to the company, and that is supported by what we call shareholder protection insurance, allowing the company to use those funds so that it is not out of funds to do the transaction, and the beneficiary gets the money rather than the shares. Another area is if you cannot come to agreement for whatever reason, of course you can force people to court, but courts do not like dealing with shareholder disputes. So much better to have an arbitration clause in, which is a commercial process. It's much faster, it's much quicker, and it's binding. An interesting clause, sometimes called a Mexican standoff, also called a Russian roulette, is where you have, say, two parties. One wants to buy the other, and the other wants to buy the other one, and therefore they can't agree on a price. What a Russian roulette clause does is it allows each party to put in a sealed envelope the amount of consideration they would personally take for their shares. Those envelopes are then opened simultaneously, and the person that has asked for the most money for their shares must pay the other party that money. And if they don't, within a given period of time, then they relinquish their shares for free. A shareholders agreement, because it's not in the public domain, is usually secondary in terms of authority to the Articles of Association. But my recommendation is always to make your shareholders agreement the priority document because it's generally much more detailed, but you actually have to state that in the agreement. You need to mention all the shareholders with their full names, addresses, and the percentage of shares they have, and also whether they are alphabet shares, i.e. different shares with different rates. What happens if you have a disagreement? And ideally, tie it all into the Articles of Association without giving too much sensitive information away. Of course, we're dealing with humans, whether it be a marriage or whether it be a company. You might have been in business as long or even longer than you've been married. And I'm afraid trust breaks quickly. Contracts are there to make sure that you can fix it if that happens. Contracts manage structure, not emotions. These early discussions, I was going to say as you're walking down the aisle, but probably when you're dating, avoid the conflict later on and the emotions are much more balanced. It allows you to separate these human feelings and issues away from the issues in exactly the same way as a prenup would do. The other thing that shareholders agreements also provide for is they provide for a list of all those items that the shareholders have removed from the directors. Directors run the business, shareholders own the business. Generally, most people's articles say that directors may do anything they wish as long as it's legal and in the best interests of the company. By having a shareholders agreement with a section called reserved powers, you say, yes, directors, you can do whatever you like as long as it's legal and as long as it's in the best interests of the company, except for. And that pushes some of the authority and power back to shareholders, which is good governance. So I just thought I'd finish with a lesson from a real case. And one of the perhaps most well-known cases where an agreement saved both parties' interests was innocent drinks. It's a product that we're all probably aware of and is phenomenally successful. What happened was the two founders, their vision completely diverged. They'd been going, I don't know, maybe 5 or 6 years, but these two young men had thought sensibly at the start of this and had a very clear, well-drawn-out shareholders agreement, which means while both parties might have fallen out, they parted amicably because they followed what was in the shareholders agreement. So a friendship that had turned into a business, which could have turned into a terrible, disastrous loss of that close personal relationship ended positively, with both parties sticking to the shareholders' agreement and walking away happily. I personally had the difficulties with a client who they set up a cladding business. A man and a woman, they weren't in a personal relationship, but they had very different views on how the business should run. They had no shareholders agreement in place. And if I tell you it literally came to fisticuffs, was when one of the partners went into the warehouse and literally started to destroy the equipment because they couldn't come to any sort of resolution. Ultimately, that business was taken to court and what's called a just and equitable winding up was invoked, which means basically that the courts say there is no way through this, so we are going to take control of this, sell all the assets, pay off all the liabilities. In this very sad case, a lot of these assets had been destroyed. And so what could have been a business that was probably worth at that time maybe 7 or 8 million was actually closed down with less than £200,000 to distribute. So if that doesn't help you to consider how serious having a shareholders agreement is, I'm not sure what can. Okay, so these are the 6 essentials of what I think are a strong agreement. As you've seen, there are lots of other things, but these are the main ones. A good defined valuation method by an independent party that is value, that is not your auditors, which is absolutely binding. Clear exit triggers. So what happens when somebody leaves? Are they a good leaver? Are they a bad leaver? Have they got minority discounts in place? A fair dispute procedure, so whether that's arbitration or whatever process you decide on, what you don't want to do is just rely on having to go to court. It's important to have this in place because while you can force people to court, you can't force them to arbitration. If there is a process where buying and selling terms have to be agreed, either they want to sell to a third party or they have to sell back to the company or to other shareholders, you need an actual log of who goes first and what the process is. And while people don't generally review their shareholder agreements, because if you've got a deed of adherent in place, if the business changes substantially, I would recommend you do review this, particularly if there's been some major changes, and I would be talking about doing that every 5 years. And finally, to say this, do it while you're dating, while you love each other, not when you're divorcing. I hope you've enjoyed that. If you'd like to hear more about it, or you'd like to talk to us about a checklist, please do get in touch with us, scan the QR code, and thank you so much for listening. Thank you. Bye-bye.